Mora is in court.
I'm going to get your water in the glass. I had hidden away. Okay, glass and water. Yes, sir.
Thank you, my lady. My lady, I was dealing with the second letter from Sanef
Yeah.
to the EFF at page 67 of the papers. The respondent's attitude to the speech made at the Zondo Commission of Inquiry is that, despite the words that we used, Mr. Malema never intended there to be actual violence, never intended anyone to be actually hurt by his words and by his call to action. Whilst that is not the test, and I'll come to the test in a moment, it's interesting that despite the letter from Sanef at page 67, MM22, there was no response from either the EFF or Mr. Malema. And I say why that is interesting is that Ms. Matlasi says, what we do, however, object to is when individual members of the media are publicly targeted, resulting in harassment, intimidation, and or threats. And she goes on. In 5, she says, on 20 November, Mr. Malema singled out several individual journalists by name, calling on his followers to write down their names and to attend to them decisively, in quotes. Implicitly, those journalists were branded as part of the enemy, whom Mr. Malema called upon to be crushed. When the enemy raises its ugly head, don't hit the head, cut the head, said Mr. Malema. And she goes on about supporters saying that Mr. Malema had given them a mandate to deal with them decisively until they become, this is the journalists, carcasses in their brains. My lady, if it was never the intention of Mr. Malema or the EFF to incite their supporters to action, which could include physical attacks on journalists, then why didn't the EFF respond to this letter? Why didn't the EFF say, that's not our intention, you've misconstrued what we were saying? Or better still, let's meet to discuss your concerns. And I'm sure there can be an amicable resolution of this matter. And if one contrasts that with the judgment that I referred your ladyship to, the Brown judgment, in paragraph 78 of the judgment, her ladyship writes, the respondents, and my lady, just to put this in context, again there was this issue of Mr. Malema tweeting Ms. Brown's telephone number and the consequences and how she was abused and intimidated and harassed as a result of that. And then she went to court. Well, she first went to the IEC, she later complained to the IEC, that wasn't successful, and then she came to the High Court. And at paragraph 78, her ladyship says, the respondents contended that the issue could have been amicably resolved if Ms. Brown had approached Mr. Malema directly, instead of turning to the IEC, and had provided the EFF with the names and contact details of the individuals who had sent the threatening messages and made the abusive calls, as she was invited to do by the EFF's national chairperson. My lady, that's precisely what Sanef did in this case. Sanef wrote to Mr. Malema and said, we have this problem, we need to meet. And the response that Sanef got from Mr. Gardi was, don't write to the president of an organization, write to me. And then they wrote to him, and again there was no response. If someone is acting appallingly in your name, if someone is making vile, abusive, harassing, intimidatory statements against journalists whom you know, and they're doing it in your name, and if it's not your intention that that be done, then surely you have a responsibility. And our submission is that the EFF and Mr. Malema had a responsibility to say, not in our name, and call on their supporters to tone it down, to stop with the misogynistic, the racist, the harassing, insulting statements and tweets. It's really common sense that should have been the EFF's response. And we submit legally that should have been the response as well. In our heads of argument, we deal with Mr. Malema's address to the supporters at 67. 68, Mr. Malema concedes that aspects of his speech may have caused offense, but he says they were justified. And primarily he says they're justified because the complainants have abused their role as journalists. And then he relies on that portion of the speech that I quoted earlier where he says, and don't kill them. My lady, in the AfriForum judgment, which I referred to earlier, which is in your ladyship's bundle, and is referred to in our heads of argument at paragraph 70, this court, the Equality Court, set out the test to be applied when determining the meaning to be attached to words at political gatherings. And there's a number of points that the court listed as an appropriate response to determining meaning. That case was about a particular song that Mr. Malema and the EFF were singing. But we highlight just a few of those from the judgment. The first is that publication of words at a political rally must be treated as publication to the nation. The second and most, well, not most important, but very important, is that the intention of the person who utters the word is irrelevant. Thirdly, the first question to be decided is what the words mean. And fourth, what the words mean must be determined by asking what the words would mean to a reasonable listener, having the common knowledge and skill attributed to an ordinary member of society. And my lady, we submit that that test is not something that's foreign to our courts. Even in the law of defamation, for example, on a slightly different point, but when one asks whether someone has been defamed, the test that one applies is how would those words have affected the standing of that person in the eyes of the average listener or the right-thinking member of society. I submit it's the same test. And so one doesn't have to have any special knowledge, but one has to be rational and with a knowledge of the circumstances in which that is being said. And the respondents will say that the whole context of that speech was they were at the Zondo Commission of Inquiry, they were there to protest against Mr. Pravin Gordhan because he was going to testify on that day, and that they took issue, and Mr. Malema took issue with journalists who had written favorably of Mr. Gordhan and negatively of the EFF. And so the slant that they put on it is that they were, in a sense, being agents of Mr. Gordhan, or as Mr. Malema says, part of the Ramaphosa Defense Force. But none of that context takes away from the meaning of the words used. We make the point that the purported call at the end of the speech by Mr. Malema to his supporters not to kill, to treat with women journalists with restraint and so on, that's inconsistent with what he said earlier in his speech and his call for action. The respondents would have your ladyship focus on that part of the speech where he says, and do not kill. But then your ladyship must ignore the first part of the speech, which is crush the enemy, cut off the head of the enemy, occupy every space in society and deal decisively with the enemy. We submit that any person who heard that would have had no doubt that Mr. Malema was advocating violence against the perceived enemies of the revolution, including members of the media and the journalists that he identified by name. And we submit, milady, that objectively, if one looks at Mr. Malema's utterances, if one looks at the tweets of the EFF following the speech, if one looks through the chronology at all the tweets that followed, objectively, there is a cause and effect apparent in the chronology. Objectively, Mr. Malema's speech spurred his supporters on to launch a sustained and targeted attack on the journalists singled out by him and other journalists. And we say, if your ladyship looks at the complainant's affidavits, your ladyship will see that connection. Milady, otherwise, objectively, this is all just coincidental. It's just coincidental that Mr. Malema made a speech where he called supporters to action. It's just coincidental that the supporters then said they were acting in his name. There's no connection between the two. It's just coincidental that Mr. Malema hits back at Ms. van Wyk and says, go to hell, Satan, and then his supporters follow in the same vein. It's just coincidental. There's no, and with respect, milady, that argument is so far-fetched that it simply cannot sustain itself. As I submitted earlier, we live in the real world where when the EFF says, fighters, let's go, then its supporters act on that. We saw that with the incident at the Vodacom stores, which is canvassed in the papers. It's not irrelevant, and it shows a specific cause and result. And there's no reason, objectively, to say that there's no similar cause and effect in relation to Mr. Malema's and the EFF's tweets and statements and the tweets of their supporters. So, my lady, we submit that the claimants have a clear right to interdictory relief, because it is the only relief, framed as we have framed it, that will bring an end to this sustained attack on journalists. And over lunch, I considered the argument that I make in relation to a clear right in the Equality Court is exactly the same argument I would make in relation to a clear right in the High Court. And so when I said earlier that we might have to come back for argument if your ladyship non-suits us on jurisdiction, I must reconsider that, because I submit that once I've gone through all the requirements for a final interdict, that argument is as good in the High Court as it is in the Equality Court. Because in the High Court, there can be no doubt that there's a right to be free from harm, to be free from attack, to be free from injury, and one could go to the High Court to say, I want to interdict against someone from threatening to assault me or from inciting others to assault me. It would be a perfectly good order. So that's clear right. Injury actually committed or reasonably apprehended. Again, all the complainants have filed their affidavits, they've set it out. My lady, I'm going to move through this quite fast. I'm not going to belabor every point. I'll just highlight in respect of some of the complainants what they say, but we have set out here with references chapter and verse from the affidavits. Paragraph 81, Ms. Munsami was singled out by Mr. Malema in that speech on the 20th of November. In 82, the ladyship can see some of the abuse that Ms. Munsami has been, and harassment that Ms. Munsami has been subjected to in tweets from supporters of the EFF. And I'm not going to repeat every time. Supporters of the EFF who are acting, we submit, in consequence of what their leaders have said. And one can see those, I'm not going to read out those vile comments. With Ms. Van Wyk over the page at paragraph 29. And your ladyship will see that what I'm doing is I'm steering clear of personal feelings, and I'm submitting objectively to your ladyship. We know that those tweets were published. We know that those tweets were directed at Ms. Munsami. So your ladyship objectively can see the effect of those tweets, or assess the effect that would have had on Ms. Munsami, particularly within the context of the definition of harassment. As far as Ms. Van Wyk is concerned, I've already highlighted that she wrote certain articles about the VBS Bank, which were critical of certain leaders of the EFF. 88.1, Mr. Malema posted, I've already discussed or dealt with that tweet. Mr. Floyd Chibambu also tweeted at her, as did Mr. Dalian Porfu. Then in 88.4, EFF supporters and followers of Mr. Malema frequently repeated his statement calling her Satan. I've already spoken about that, but the footnote is there. And then in 88.5 is the misogynistic tweets that I referred your ladyship to. And I just ask your ladyship to read those and to look at those tweets. But if one's supporters are saying that against journalists, there is an obligation to set them straight. There have also been sexual innuendos made, and her home address has been requested. I've dealt with the rest already, simply to say that in 91 that Ms. Van Wyk also fears for her safety. It's the same point I made about Mr. Bateman. Mr. Basson has also been criticized by Mr. Malema. This goes back to as early as the 5th of July 2018. Mr. Malema has called him a racist. EFF supporters have called for propaganda media houses to be burnt down. No doubt that supporters are contemplating acts of violence against the media. And then other vile statements in 94.3. Then in 94.5 there's reference to the EFF supporter who posted that Mr. Basson should be killed. And then Mr. Basson asked Mr. Malema whether the EFF was going to condemn it, and Mr. Malema said no, they're not going to be doing that. So instead of, this is a case where the EFF is not standing quietly by and not acting, but this is a case where the EFF is being asked to condemn, much along the lines of the letter from Ms. Mahlase from Sanef. And the EFF is saying, no, we're not going to do it. Mr. Dupree was one of the journalists who was singled out by Mr. Malema at the rally. That was on the 20th of November. This is a rally at the Zondo Commission of Inquiry on the 20th of November. On the 21st of November, at the Zondo Commission of Inquiry, Mr. Dupree is there to attend the hearing, and he gets attacked by EFF supporters. He's also been subjected to extreme harassment on Twitter. That's paragraph 99. And he's been warned by EFF supporters not to criticize the EFF. Mr. Bateman, I've alluded to this already, my lady, about the House, the relationship between Mr. Malema and Mr. Mazotti in the House, the conduct of Mr. Jacques Poe in tweeting the street address. It had the incorrect house number, but that doesn't matter. The point is, Mr. Jacques Poe should never have done that. Sanef said as much, and he corrected himself. Now, despite the fact, my lady, this is at 104, despite the fact that Mr. Bateman was not the source of the post about Mr. Malema's address, he and his wife have been subjected to a series of threats by EFF supporters, and that's all set out in page 34 of our heads. And this is where Mr. Bateman talks about the tweet that was retweeted by Mr. Malema about the list of journalists' home addresses. So, my lady, that brings me then to page 35 of our heads in paragraph 105, where we deal squarely with the respondent's defense that the EFF and Mr. Malema should not be liable for the conduct of people who identify themselves as EFF supporters. He says they don't know them, they can't discipline them, they're not responsible for their tweets. Now, that was the same argument, my lady, that was raised in Brown versus Economic Freedom Fighters, EFF. And in particular, if I could take your ladyship really, it starts at page 19, paragraph 68 of the judgment. At paragraph 68, her ladyship says, whilst Mr. Malema also stated at a press conference on 6 March 2019 that no person should be threatened with rape and violent crime, he made statements of and concerning Ms. Brown, which restated and emphasized the very basis on which the harassment of Ms. Brown had been based. My lady, it's the same conduct here where Mr. Malema on the one hand says, don't kill them, and on the other hand says, cut their heads off. There was no attempt to curtail the self-professed EFF supporters from continuing with their harassment of her, or any instruction to them to desist from their conduct. It's also unclear whether all of the 2.83 million Twitter followers would have been aware of the press statement or would properly have contextualized or appreciated Mr. Malema's statement that no person should be threatened with rape and violence. And that's the point I made, my lady, of supporters listening to one part of the speech, not listening to another part of the speech, supporters seeing one tweet, not seeing another tweet. And even if they see both, still there's this mixed message coming through. 69. In their answering papers, the respondents did not meaningfully address their failure to take any steps or stop or stem the tide of abuse and intimidation directed at Ms. Brown, despite such facts being peculiarly within their knowledge. It was not suggested that they were not aware of their obligations under the code, that's the electoral code, or that there was any attempt at compliance with such obligations. And then, if I could ask your ladyship to turn to page 21, paragraph 75. What steps would be considered objectively as reasonable would depend on the circumstances. In the present instance, it would be reasonable to expect the respondents, once they have been aware of the barrage of tweets directed at the applicant, to take active steps to admonish their supporters and to caution and instruct them to refrain from their offending conduct. Considering the content of the tweets directed at Ms. Brown, they fall well within the ambit of being harassing, intimidatory, hazardous, and threatening. The respondent's conduct falls short of what a reasonable person would consider reasonable in all the circumstances. When requested to intervene and instruct their followers on Twitter to stop the harassment of Ms. Brown, the EFF ignored the requests and Mr. Malema refused to do so. And so it goes all the way up to paragraph 79. On the respondent's own version, it was not disputed that they were fully aware of their actions and specifically the consequences of their inaction, the impact thereof on their supporters and the conduct and consequences which follow. My lady, Mr. Malema, the EFF, they're on Twitter a lot. Let me not exaggerate, but they are prolific Twitterers. I don't know what the tweeters. And particularly when there's a reply to Mr. Malema or a reply to the EFF, they can see the tweets, and certainly there are topics such as when topics trend and so on. People who are on Twitter are aware of a lot of what's happening on Twitter, obviously not everything. But then Sanef brings it to the attention of the EFF, and Sanef says, let's meet. And they still say no. Well, first of all, they say you directed to the wrong person, and then they simply don't do it. And her ladyship says this: if the respondents did not deliberately intend them, that is the consequences of their statements and the consequences of their tweets, they at least stood reckless to the results, which, although they may not have foreseen them initially, were reasonably foreseeable once they had been brought to their attention on more than one occasion from different sources. The explanations proffered for failing to take any steps do not pass muster. Importantly, the respondents did not need to know the identities of their followers to instruct them in general to stop intimidating or threatening Ms. Brown. A general and abstract condemnation of abuse is not what was reasonably required from the respondents. And, my lady, we submit that the same applies in this case. The respondents' big defense is we don't know who these people are. But these are people who are saying we are doing things in your name. They profess to be EFF supporters. The EFF and Mr. Malema are duty-bound to take steps to ensure that people who act in their name are left in no doubt that they are not acting in the name of the EFF or Mr. Malema. My lady, then the absence of a satisfactory alternative remedy. Again, I would refer your ladyship to, from paragraph 109 onwards, it's the letters, the requests to Sanef, from Sanef to the EFF to intervene, to stop the harassment that was taking place. And we make the point in 112, it is clear from Mr. Malema's answering affidavit that he and the EFF believe that the complainants are to blame for the attacks on them, and that they accept no responsibility for the conduct of their members, and I might add there, or for the conduct of their supporters. And we submit that unless the interdict as sought is granted, that nothing will change, because the EFF and Mr. Malema believe that these journalists are not entitled to any protection, that they themselves have descended into the political arena and are fair game. They will not intervene whilst their supporters intimidate, harass, threaten and assault the complainants and other journalists critical of the EFF. In fact, not only will they not intervene, my lady, they will continue to make statements and to tweet in a way that incites their supporters. My lady, can I just make one point about the order, and then I will end. I'm talking about Annexure B. In prayer 4 on page 8,
yes,
we ask for an order interdicting the respondents from expressly or tacitly endorsing the publication of personal information. And in prayer 2, it's interdicting the respondents from publishing personal information. So the one is interdicting the respondents themselves, and the other one is interdicting them from endorsing or inciting. But I'm focusing on the words personal information. The respondents in their affidavit say that this is too wide because, for example, an email address might be personal information, and those email addresses are freely available. From the papers that are before your ladyship, the personal information that is spoken about and that is addressed in the papers is the home addresses of the individual complainants. But in light of the Karima Brown judgment, I would submit that that should also include telephone numbers of the individual complainants, which was the case in Brown. And when Mr. Malema was taken to task on that, he actually withdrew and said that he never intended to publish Ms. Brown's telephone number. So I would ask that the words personal information in 2 and 4 be home addresses and personal telephone numbers. But for that, I just point out that in 7, we ask for costs, including the costs of 2 counsel, But we do ask for a punitive cost order, and that is because, and I'm not going to go over it again, but if Mr. Malema and the EFF had taken up Sanef's offer to meet, which was made on 2 occasions, and if the EFF and Mr. Malema had been bona fide and intent on resolving what was obviously a concern for Sanef and the journalists, then it is quite possible that an agreement could have been reached, which would have rendered this complaint unnecessary. But that never happened, and here we are. So we ask for a cost order in terms of Press 7. We ask for an order in terms of Press 1 to 7, with the necessary amendments to 2 and 4. And we say, my lady, that order can be granted either with your ladyship wearing the hat of an equality court judge, or with your ladyship wearing the hat of a high court judge. Thank you, my lady. I have no further submissions.
Okay, I'll wait for your reply. I won't ask any question which I wanted to ask.
I'm happy
because
to take
Because I'm sure the respondent will address that. Thank you.
As your ladyship, please.
Thank you. We agree that the Advocate Kasi will...
As the court pleases, my lady, I'm just going to have the lectern.
Okay, thanks.
She's coming.
On behalf of Media Monitoring Africa, if I may hand up a bundle of authorities.
Yes, you may. Thank you.
I have already circulated a copy to the other parties. Milady, you'll note that there's one document, one UN resolution of 2018 that's missing from that bundle. But
okay.
We will ensure that that is added to your bundle
okay.
through arrangements.
I would appreciate that.
Milady, Media Monitoring Africa is an NGO that acts as a civil society watchdog and seeks to protect the rights and freedoms, rights to freedom of expression and the rights to freedom of the media and the advancement of ethical and fair journalism. It has been admitted as an amicus curiae in this matter on 2 grounds. The right contained in sections 16(1) and 2 of the Constitution, and the importance and impact of international law to the present dispute. Milady, at the onset, it is worth reiterating what is stated in our application for leave to intervene, and this is that MMA's position has always and continues to be that freedom of expression may justifiably and correctly be limited in certain circumstances. In this regard, we refer the court to the stance MMA has taken in the cases listed in our heads of argument at footnote 2. However, my lady, we submit that the present inquiry before this court is a different one and does not squarely involve the question of the curtailment of media freedom. At paragraphs 3 to 18 of our heads of argument, we set out considerations relevant to the admission of the MMA to the proceedings. Having been admitted, I do not deal with these paragraphs, and I move directly to paragraph 19 of our heads, which is the commencement of our legal submissions on section 16(1) of the Constitution. We outline these principles with the knowledge that the Equality Act is aimed at amplifying and giving meat to section 16.2 of the Constitution. We nevertheless focus on 16.1 because in our view it is critical to this court's determination of whether there's an infringement of 16.2 and, in its application, section 10 of the Equality Act, to understand the ambit of the freedom and protection afforded to the press and the media. The importance of the media within the right of freedom of expression is in large part in its role in advancing democratic participation and accountability. This is particularly clear in the present case, where the complainant journalists are all political and/or investigative journalists, whose professional duty it is to report and provide journalistic opinion and views on current political and government activity. For this reason, these particular journalists and their work, we submit, is worthy of protection in that they work at furthering citizen autonomy and the ventilation and tolerance of contested views within society. The value of contested views, in this case political views, my lady, in society is not to be understated. It facilitates the right to receive and impart ideas, protected under section 32 of the Constitution, and enables citizens to realize their rights to dignity and equality as against those in power and authority in government. My lady will note that we've cited Islamic unity at paragraph 45 and the Kamala judgment at paragraph 22 in this regard. And my lady, we've quoted the Kamala judgment fairly extensively so as not to take the sentiments out of context. But it is worth emphasizing to my lady that in our heads at paragraph 9, where we've quoted Kamala, my lady will note that at paragraph 23 of that judgment, it says, the media are important agents in ensuring that government is open, responsive, and accountable to the people, as the founding values of the Constitution require. Over the page, at paragraph 24, the judgment reiterates that the mass media play a role of undeniable importance. It says further down in that paragraph that they are extremely powerful institutions in a democracy and that they have a constitutional duty to act with vigor, courage, integrity, and responsibility. The manner in which the media carry out their constitutional mandate will have a significant impact on the development of our democratic society. The rest of the paragraph, my lady, explains the importance of a scrupulous and reliable media and the value that has in strengthening a fledgling democracy, in the words of the court. The High Court in Holomisa further stated that this role of the media in relation to political views is the success of our constitutional venture, in fact, depends on robust criticism of the exercise of power, and that this requires alert and critical citizens. In Islamic unity, my lady, the Constitutional Court confirmed the need to protect fairness and diversity of views broadly representing South African society, a mandate which is hardly surprising, it says, in a country still riddled with legacies of inequality. We submit that this balancing of rights between the protection of the work of journalists and the rights to robust political expression by the respondents must have at its core a consideration of whether the EFF's conduct ought to be recognized as part of a concerted campaign to use their influence and tools within their sphere of authority to cower and intimidate the named journalists from their professional and constitutional mandate for fear of physical or other harm. The ramifications of permitting such conduct by the respondents we submit, or endorsing such conduct by the respondents we submit, has broader societal implications. That of stifling media reports engaged in subject matter that the respondents, as one of many political parties, my lady, not the sole political party, takes issue with. We submit that once fear, intimidation, and harassment is permitted to continue under the guise of robust political expression, the free distribution of diverse and contested information suffers. Now, my lady, the submission, you will note, that I've made on section 60 makes an underlying assumption that journalists are in their own right a recognizable group worthy of protection. The respondents contest this through reliance on the Equality Act, which in its definition of prohibited grounds does not include in its ambit trade or occupation. We, however, submit that this on its own is not a bar to the relief sought by the applicants. In support of this position, we place reliance on international law. Indeed, trade or occupation may fall within the unlisted grounds in subsection B3 of the Equality Act's definition of prohibited grounds. This court, as my lady is aware, is mandated to consider international law when interpreting the Bill of Rights. This position is reiterated in the Equality Act itself in Section 3. Section 3.1 requires that of the Equality Act requires that courts take into account the Constitution, and Section 3.2b requires courts to be mindful of international law and international customary law as two sources of law. Like the MMA, the respondents recognize the importance and relevance of international law in this matter, and they too refer to Article 19 of the ICCPR. The full ambit of Article 19, my lady, is set out as quoted in our bundle at page 101. But of relevance is, my lady, the font is a little bit small, but it's on the left-hand side, page 101.
101.
101.
Okay.
And it's halfway through the text on the left-hand side. The lady will note that it's numbered paragraph 1, and it says recalls in the context of this resolution.
Yeah, got it.
However, I would like to point out aspects of Article 19, which states that everyone shall have the right to hold opinions without interference, and for the protection of freedom to seek, receive, and impart information and ideas. Now, what is interesting, my lady, is that in giving context to this article of the ICCPR, the General Assembly has issued a number of resolutions on the application of this article in relation to the safety of journalists. So taking that article from the broad and overarching to the particular, and to what the General Assembly of the United Nations recognizes as a vulnerable group. I have quoted, my lady, in our heads of argument the relevant extracts from each resolution in turn, from paragraph 28 of the heads. The resolutions in their full text are contained in the bundle from page 100 to 110. Now, what is of use, my lady, is that there are certain, as with most General Assembly resolutions, there are certain phrases, acknowledgements, and concerns that might be reiterated and repeated from one resolution to the next. But what is apparent from the 2018 resolution, my lady, which is at my heads of argument, page 60, is, and at paragraph 36 of the heads, is that for the first time, the General Assembly recognizes that through online media and through the development and challenges in the professional environment, that the media is constantly evolving, and that there are targeted disinformation and smear campaigns to discredit the work of journalists, and that this is increasing. And then, in relation specifically to women journalists, the resolution records that it is deeply alarmed at the specific risks faced by women journalists in relation to their work, and underlining in this context the importance of taking a gender-sensitive approach when considering measures to address the safety of journalists. And it continues, including in the online sphere. And it specifically says conduct such as sexual and gender-based violence, threats, intimidation, harassment. gender-based stereotypes, and so it goes on, my lady. And then we have, for the first time, the 2018 resolution says that it is allowed at instances in which political leaders, public officials, and all authorities denigrate, intimidate, or threaten the media, including individual journalists, which increases the risk of threats and violence against journalists and undermines public trust in the credibility of journalism. The last caution that is contained in that resolution, my lady, is also contained as a caution in the 2016 resolution, and that is that states take positive action to prevent impunity for attacks and violence against journalists. Now, considered in total, my lady, the MMA would submit that the General Assembly resolutions do 4 things. It recognizes the importance of the freedom and protection of journalists and the media in general in the furtherance of an open and democratic society, and the right, the correlated right of members of society to be able to receive and impart information and form opinions on such information. It secondly acknowledges the particular types of threats to independent reporting that journalists may face. My lady, we note that these types of threats are set out in varying degrees of severity in these resolutions, from threats, intimidation, and harassment, which I pointed out to my lady, to more serious curtailments such as detention or killing or disappearance. The fact that the resolutions are drafted to include such a wide ambit of conduct does not detract, we would submit, from the fact that threats, intimidation is sufficient as a jurisdictional fact for the invocation of the resolution, or in our constitutional language, it would be for consideration of that international law principle in our domestic law. Thirdly, the resolution notes that the threats to media freedom may be a concerted stratagem aimed to stifle the free expression of opinion and suppress the circulation of contested ideas or views. And finally, calls on states to do 2 things. First, ensure accountability so as to prevent attacks against journalists occurring with impunity or without recourse. And second, to take positive steps to support an independent media that is free from undue influence, to raise awareness of the importance of an independent media, and to take prompt action when journalists are threatened, harassed, intimidated, or exposed to violence. And this is the important bit, my lady, as a result of their professional work. And this is reflective, we submit, of the dicta of positive steps referred to by the court in Brown, to which my learned friend has already taken the court through. Now, the injunction, as is apparent, is on states to take action. The lady, of course, the state under our constitution includes the judiciary and includes different branches of government. And so we would say that not only is this court able to take into account these international law principles, but also able to ensure that accountability and positive steps are taken. Now, when we apply these principles to the domestic context at hand, we would submit that it is incumbent that South Africa, or our courts, recognize the particular threats to and the vulnerable class of persons identified as journalists. To do otherwise, we would submit, would be to create a schism and a possible parallel development of South Africa's legal obligations in the international sphere and domestically. This approach, we say, would be in line with the injunction in section 233 of the Constitution that courts must prefer any reasonable interpretation of legislation that is consistent with international law. This also finds support in Gleniston, I believe it's paragraph 78, my lady, I'll have to double check, that divergence between our law on the international plane and domestic plane should be avoided. Moreover, the international law stance is also in alignment and in fact bolsters the constitutional position that we have got under section 16 and the case law that I've already set out in relation thereto. The interdict sought by the applicants pertains both to a claim of hate speech and of harassment, my lady, and we submit that these naturally ought to be considered separately. And we submit that once it's accepted that journalists who receive a form of special protection in the international sphere, and indeed have numerous resolutions set out in which there are protections provided and guidance given to states as to how to deal with threats against media and individual journalists, we would submit that they may well be worthy of protection under subsection B3 of the Equality Act on prohibited grounds. Milady, those are our submissions, unless there are particular questions.
Thank you. Yes, Advocate Murugai Toby.
Thank you, Madam. I made a shorter note as a guide for my submissions. And we also have core bundles of authorities.
Thank you.
If I could start by ending those two documents.
Yes, you may, sir.
For the amicus, because they're the ones who are in time. The respondent. It's these ones you ended up just now. The ones that ended up just now, and those ones are for the ones of the agreements.
Yes, sir.